All right, welcome. We're going to start. It's nice to see everybody here, as usual, sitting farther back than the seats, but that will be a constant. I will constantly try to bring you up to the front. So I'm going to give the same introduction that I give because we are also putting all of these online and each is independent. So I'm going to remind you yet again of the purposes of this class. So I'm Deborah Satz, and along with Paul Brest, I'm co-leading this class. This is the second year that we've done it. And the motivation for the class is pretty straightforward. It's that we live at a time of deep disagreement, from arguments about immigration, taxation, foreign policy, reparations, the Mideast crisis, and the function of elite higher education, even the value of free speech itself. So disagreement is pervasive, but our view is that disagreement itself is not a problem. It's a feature of democracy, not a bug, that people disagree. I was actually reading an essay last night about Darwin and Laplace, and this idea that Laplace had this idea that if you knew everything about the world, you knew every fact, you would be able to know everything about the future, and you would know everything about how things would proceed. And I thought, that isn't right, because people make different decisions and judgments on the basis of what the facts are. And human beings will always fail to converge completely on many, many important topics. And that doesn't mean that there's necessarily a flaw. It means that sometimes facts are underdetermined answers. Sometimes we don't know a lot, so that's the Laplace thing. We could know more, but even when we know a lot, people make different trade-offs among values and bring different experiences and viewpoints to what kind of trade-offs are best. However, even though disagreement is a feature of democracy, not all disagreements are productive. And part of the goal of this class is to introduce you to and model productive disagreement, disagreement that is reason-based, that's respectful, and that helps for you to think through the issues, because many of these are issues that you yourselves need to come to a decision about, whether as individuals or together as part of a collective. For those who are coming in, please, we're going to put up the attendance screen, so please sign in if you're a student enrolled in the class. And I'm going to, with this introduction, turn it over to Paul, who will say a few more words in introduction and then introduce the speakers and the topic.
Next week, I think we're going to start cold calling people in the back. So if you want to avoid being called on, you better sit in the front this week. So Deborah has explained why disagreement is important for democratic institutions. And I just want to add a word about why it's important for your acquisition of knowledge. Some of you are in College 102, Citizenship in the 21st Century, where a couple of weeks ago we studied John Stuart Mill. And this goes to the point about knowing everything. John Stuart Mill, who knew a lot, was skeptical about people who thought they know everything. So here's a quote from him. "He who knows only his own side of the case knows little of that. His reasons may be good and no one may have been able to refute them. But if he's equally unable to refute the reasons on the opposite side, if he does not so much as know what they are, he has no ground for preferring either opinion." Nor is it enough that he should hear the opinions of adversaries from his own teachers, presented as they state them and accompanied by what they offer as refutations. He must be able to hear them from persons who actually believe them. He must know them in their most plausible and persuasive form. And that's been the pattern of this course from when we began teaching it last year, and I'm sure you will find it continued today. Let me just say a few words about today's topic. Over the course of several centuries, Americans have come to accept that the Supreme Court has the final word in interpreting federal laws and the national Constitution. Robert Jackson, one of the court's great justices, wrote in 1953, "We are not final because we are infallible. We're infallible only because we are final." Yet President Andrew Jackson is said, perhaps apocryphally, to have commented on an 1832 Supreme Court decision, "The Chief Justice has made his ruling, now let him enforce it." More recently, before he became vice president, J.D. Vance said, "I think that what Trump should do is fire every single mid-level bureaucrat," has come to be, "and replace them with our people. And when the courts stop you, you stand before the country like Andrew Jackson did, because this, I think, is a constitutional level crisis if we continue to let bureaucrats control the entire country." Lest you think that arguments against judicial supremacy only come from the populist right, let me cite a book by my successor as dean at Stanford Law School, Larry Kramer, an avowed liberal. In his 2005 book, The People Themselves, Popular Constitutionalism and Judicial Review, Dean Kramer, who's now president of the London School of Economics, argues against a judicial monopoly of constitutional interpretation and for what he calls popular constitutionalism, constitutional interpretation by the people. But as I said, the virtually unanimous view of scholars and politicians today is that once the Supreme Court has spoken on an issue, its word is final, unless overturned by an amendment to the U.S. Constitution. This was certainly the assumption underlying the commission created by President Biden in 2021 to consider ideas for reforming the Supreme Court. A number of different and independent concerns led to the creation of the commission, ranging from the idea that the appointment and decision process had become overly partisan in an increasingly polarized society to the rather old age of many justices. Before introducing today's guests, let's put up a poll. We'll proceed each week's conversation, as you know, with a poll on a relevant question, and then ask the same questions after the conversation and the Q&A session. What conclusions you draw from the poll and from different results, if they differ, is completely up to you, but if nothing else, it may provide some food for thought after the class. So let's take a look at the poll. Should the composition of the U.S. Supreme Court be reformed? Trevor, can you read and see the answer?
Two to one,
Yeah.
yes.
2 to 1 yes. So keep that in mind, and we'll see what happens in an hour or so. Anyway, let me introduce two important constitutional scholars to discuss the issues. Will Baude was a member of the Presidential Commission I just mentioned. He's the Harry Kalven Junior Professor of Law and Faculty Director of the Constitutional Law Institute at the University of Chicago. He teaches federal courts, constitutional law, election law, and conflict of laws. He's an expert on the topic of constitutional originalism and the co-editor of 2 textbooks, including the venerable Hardin Wexler's Federal Courts in the Federal System, from which I studied 50 years ago. Though looking at Will, I don't think he was among the original authors. After attending University of Chicago and Yale Law School, he clerked for then-Judge Michael McConnell and Chief Justice Roberts on the Supreme Court. Before joining the Chicago faculty, he was a fellow at our own Constitutional Law Center at Stanford Law School, which Judge, now Professor O'Connell, now directs. By the way, we'll be hearing from Professor O'Connell and his colleague Bernadette Myler next week on the topic of judicial immunity. Daniel Epps is a professor of law at Washington University. He teaches and writes about constitutional law and theory, federal courts, and criminal law and procedure. He's an experienced Supreme Court litigator and has particular expertise in Supreme Court reform with his own proposal to restructure the Supreme Court. Professor Epps has an undergraduate degree from Duke and from a degree from Harvard Law School, where he was articles co-chair of the Harvard Law Review and won the John Olin Prize in Law and Economics. After law school, he clerked for Judge Harvey Wilkinson on the Fourth Circuit Court of Appeals, and then for Justice Anthony Kennedy, a Stanford graduate on the Supreme Court. Daniel and Will are old friends and colleagues. They co-host a podcast called Divided Argument. In fact, before this afternoon session, they did a podcast at the law school. So Daniel will speak first, and then Will follow. You can, whatever your preference, you can sit down or you can stand up.
Stay here, is that okay? Whatever you want. Paul, thanks so much for that gracious introduction, and Deborah, thanks for having me. I'm pleased to see that the poll is going away, because I was nervous that I was going to see support drop in real time as I talk, because my argument is going to be that the structure and composition of the Supreme Court does need to be changed. That topic may seem a little irrelevant at this exact moment. I'd say there's no prospect of meaningful Supreme Court reform, certainly in the next 4 years, while Donald Trump is president, because for reasons I'll talk about in a second, the structure of the Supreme Court is always going to have, whether we should change the structure of the Supreme Court is always going to have an ideological valence. Right now, the way the Supreme Court works is, amenable to Republicans and conservatives, and liberals and Democrats are unhappy with what's going on at the Supreme Court. That fact does make it somewhat hard to have conversations about these issues, because there's always going to be ideological stakes. And I recognize that I'm someone who's sort of more on the left end of the spectrum, and I'm someone who thinks the court should be reformed. Will, I don't want to pigeonhole him, as a bit more conservative, and he's going to be a little bit more skeptical of Supreme Court reform. I don't know if it's a coincidence, but I got the blue mic and he's got the red mic, so we're ideologically color-coded here. But my argument is going to be that there are good reasons to change the way the Supreme Court works, change its structure, that you should agree with, even if you are ideologically happy with the Supreme Court, that there's a nonpartisan case for changing the structure of the Supreme Court. And I think we should recognize that anytime we're talking about the basic structure of government and whether it should be changed, things like the Electoral College, there's always going to be someone whose ox is getting gored, right? The structural arrangement at any given time is always going to benefit one side. That doesn't mean we shouldn't be able to at least try to step back and think through the arguments without, without the argument being totally based on whether our team wins or loses. And so my argument is going to be that there are reasons to want to change the court that go beyond just someone's, a left-wing person's bare desire to get different results from the Supreme Court, even though acknowledging that that ideological motivation is going to play a big role in these debates, right? If you look around, who is proposing Supreme Court reform? It's, Democratic representatives in Congress, Democratic senators, not Republican representatives and senators. Okay, the premise of my argument is that having a Supreme Court that is perceived as independent and legitimate is really, really important, because we need an institution that is capable of resolving some disputes that most divide us as a nation. The court is never going to be able to find solutions to some of these issues that divide us the most, solutions that make everyone happy. But ideally, the court can provide results on some of these issues that even people on the losing side can accept and end conflict in that way. So an example of that is the litigation that produced the decision Bush versus Gore. And that was in 2000 election. It was a very, very closely contested election. There was a lot of litigation about how to count the ballots in Florida, and eventually the court stepped in and said, basically, this has to stop, basically said Bush won. And a lot of people were unhappy substantively, but people just kind of accepted the decision. And you can make an argument that it was good to have an institution that could just tell us, let's stop fighting about this, let's get on with things. But so to be able to do that, the court needs what we call legitimacy. And the political scientist, James Gibson, puts it this way: legitimacy is for losers. The idea being that institutions that have legitimacy is important because it makes the people that lose respect the outcome. And the problem is that legitimacy is not an objective truth. It's a sociological fact about what people in society believe. Do they trust the court? Do they respect it? Do they think it's reaching decisions in a principled, fair way? Or do they just see it as a purely partisan institution? And I think when you understand legitimacy that way, I think it's hard to dispute that the court in the last 5 or 10 years has really lost some of its legitimacy. Certainly if you look at public opinion polling, the court is polling much worse than it did. It's still more popular than some of the other branches of government, but its reputation has taken a hit. And people who don't agree with what the court is doing, liberals, are much less likely to respect the court and respect its decision-making. And my argument is that the reason that this is happening, two things. I mean, first is that that's bad, right? That even if you like what the court is doing, it's ultimately bad for everybody to have a court that is losing its ability to resolve issues in ways that everybody can live with. And the second part of my argument is that the reason this is happening is because of some structural features about the court's composition and structure that are kind of combining to get us to where we are. And so let me walk through what I see as the factors contributing to the problem. So first, justices have life tenure, okay? They cannot be fired, they cannot be forced to retire, they serve until they decide to resign or they die. And vacancies on the court, as a result of that, are unpredictable because they arise from some combinations of retirements, and we also often see something we call strategic retirement, where a justice will retire knowing that they're likely to be replaced by a president who they agree with ideologically. Strategic retirements, but also unexpected deaths, like Justice Ginsburg's death in the fall of 2020. Second factor, justices are serving for longer and longer periods. Their typical length of service crept up significantly in the latter part of the 20th century, with average tenure starting to approach 3 decades on the bench. Third, the court is pretty small, only 9 justices, and you only need 5 justices to issue a majority opinion. A smaller court means fewer vacancies, and it means that any one appointment to the court is more consequential. Fourth, the court is incredibly powerful. Its prestige and authority have grown tremendously since the founding. It's now expected to, and it does, weigh in on almost every major government action of any consequence. And then finally, and I think most importantly, we live in a highly and increasingly polarized age. Political parties and voters are more polarized than they've been, at least in a very, very long time. And now we have a deeply polarized legal culture as well. We have basically 2 different legal communities. We have a conservative legal culture, and they go to events sponsored by the Federal Society. We have a liberal legal culture, and they go to events sponsored by the American Constitutional Society. And there's reason to think that the ideological distance between the political parties is increasing, and the ideological distance between those 2 legal cultures is also increasing. And then the end of the Senate filibuster has also removed a moderating influence on the selection of nominees for Supreme Court justices. Okay, so you combine all those factors I just mentioned, life tenure, court small size, tendency of justices to remain on the court longer, means that vacancies are rare, they're unpredictable because of death and retirement. But those unpredictable events are extremely consequential because the court is powerful and because our polarized political and legal cultures produce justices who decide cases quite differently depending on the political party of the president who appointed them. And we now have a court where ideology of the justices perfectly tracks party of appointment for the first time in American history. And recognizing this point is not the same thing as saying that the court and the justices all decide cases on a purely partisan or political fashion. I don't think they're just looking up well, what does the Democratic Party want, what does the Republican Party want, let's vote that way. Many of the court's cases are unanimous. Many of the non-unanimous cases don't break down on party lines. But I think anybody kind of familiar with what the court does is going to have a hard time denying that there is a pretty close relationship between party of appointing president and judicial ideology and judicial method, and that matters a lot in some of the cases that have the highest stakes. And my claim is that this creates a very big problem for legitimacy, because the current shape and membership of the court is very hard to justify in a way that seems fair to people that are on the losing side. Individual appointments to the court are immensely consequential. Strategic retirement and Senate obstructionism can mean that filling any given vacancy could leave that seat in one party's hands for more than a generation. And this means that in our system, the composition of the court bears only an imperfect relationship to the results of democratic elections. Accordingly, some presidents have much more influence on the court's membership than others. Even though Democrats controlled the White House for 24 of the last 56 years, due to happenstance and other factors, Democrats appointed only 5 justices during that time, while Republicans have had 16 appointments. And the reason that matters comes back to what I was saying about legitimacy. One side of the country, I think, looks at these structural arrangements and sees the system as unfair and rigged. According to some empirical research I and some co-authors have done, there's a realistic chance that there will not be a majority of the court appointed by Democratic presidents at any point in the next 100 years. Half the country is going to think that that's fantastic, but for the half that doesn't like that, they're going to increasingly see a system in which only one party gets to control the court as illegitimate and not worthy of respect. And I see this system as pretty indefensible. The path of the law and the resolution of the questions that most divide us as a country shouldn't turn on whether Ruth Bader Ginsburg gets cancer and dies in September of 2020 or whether she survives a few more months. And so we can argue about whether the court should be seen as legitimate or not. My claim is that those arguments aren't going to produce consensus. They're not going to accept the losing side to accept defeat on these issues that divide us the most for generations. And so until we're willing to address the structural problem, things are going to get worse before they get better. And if you care about the court, and if you really care about American society, and you care about having an institution that can definitively settle some of the issues that really divide us, you should want to prevent that from happening. How would we do that? I'm not going to get into the details of a lot of proposals, but we can talk about those later. But just to quickly list some possibilities. One option that a lot of people like is term limits. We could have term limits for Supreme Court justices. One common proposal is to have 18-year term limits with staggered end of term, so that each presidential term, the president gets to appoint 2 justices. There's other ways you could do something like that. You could just say, we're going to keep life tenure, but each president just gets to nominate and confirm 2 justices. I've proposed a couple different solutions in my research. One is having a court with kind of fixed partisan balance requirements. There's always going to be 5 justices selected by Democrats, 5 by Republicans, 5 justices in the middle. You could draw more justices from lower courts. I think there's a lot of options here, but I do think the current system is very, very hard to justify, and things are, the court is only going to lose its legitimacy further while it is seen as a partisan institution.
Thanks, Dan. Thank you all for having me. I think this is a very important topic, and I think about it very differently, so I thought I'll lay out how I think about it. I agree with a fundamental point of Dan's framing to start with, which is that you can think about Supreme Court reform from kind of either a partisan lens or a nonpartisan lens, right? So the partisan lens, which is a view some people have, is something like, I'm a Democrat. The Supreme Court is controlled by Republicans doing Republican things. Therefore, that's bad, and we Democrats should do everything we can to control the Supreme Court and make it do Democrat things. That is a sort of straightforwardly partisan view. You can dress it up a little bit by saying, I'm a Democrat, I believe in X, Y, and Z. The Supreme Court is doing the opposite of X, Y, and Z. Therefore, we need to do anything we can to control the Supreme Court and stop it from doing X, Y, and Z. But that still amounts to the kind of an outcome-based view of controlling the Supreme Court. In politics, people can have whatever views they want. I think partisan Supreme Court reform is kind of inherently unproductive and self-limiting. In a country where roughly half of the people disagree about things, it's never going to happen that one half will somehow be able to control all the rules for creating and packing the Supreme Court and be able to bring about lasting control of the Supreme Court that way. So most people who want partisan Supreme Court reform feel some pressure to dress up their views in nonpartisan terms and try to find some way to get to nonpartisan Supreme Court reform, even if their real motivations are partisan Supreme Court reform, the question of whose ox is gored. I think the partisan Supreme Court, the partisan court reform approach is unproductive and wrong. I'm happy to talk about it more. But as you'll notice, that's not the approach in the argument Dan makes. He instead argues there's sort of a nonpartisan case for Supreme Court reform, right? Putting aside just the view that you might be a Democrat, think the Supreme Court should be controlled by Democrats like you, there's some broader legitimacy-based view that people of both parties should agree with for why we should have Supreme Court reform, and a lot of the conversations happen in that lens. And so many proposals we see, like term limits because the justices shouldn't serve for life, court packing for one reason or another, partisan balance requirements, changing the appointments process, are arguments made in some kind of a good government fashion that sort of people on both sides should believe in this. And I think they mostly fail and are unconvincing. So I think it's not a bad thing that the justices have life tenure. Again, holding constant who the justices are, right? So it might be a bad thing that justices you don't like have life tenure because you'd like to have less of them. Well, holding constant who the justices are, life tenure actually has a lot of important structural virtues. One thing it means is that the justices are never thinking about their next job. So if you look at people in high-placed executive branch appointments, people in Congress, there's a well-known revolving door problem where people are making decisions while they're in power, thinking in part about what they're going to want to do when they're out of power, to keep their options open or become part of some, whether it's to make money or ingratiate themselves with an ideological movement or to boost their own options. That is not something we see from our Supreme Court justices, and that's a good thing. It would be bad if our Supreme Court justices were worried about making sure they were in a position to be able to make a lot of money at a law firm or become the president of a ideological think tank or a TV star or run for president or whatever it is they would do if we were to tell them they couldn't be on the Supreme Court anymore. And indeed, the fact that they know that they're in it for life means they have the maximum incentive to invest in the Supreme Court as an institution, to try to work together and find some way to boost the Supreme Court's legitimacy, exactly what we need from them. Similarly, the fact that the Supreme Court is small actually I think is very conducive to the justices working together. They build relationships. They know they're in a very long-term sort of repeated game, so to speak, at building an institution. And the fact that it's small means they have to work together, have to figure out ways to work together year after year. It means they bear more responsibility for their output. There are few enough of them that if the Supreme Court does something controversial or wrong, we know which justices are to blame. When a decision is 5-4, we know that every justice in the majority could have had it be otherwise, right? When it's 6-3, we know that any two justices bear the responsibility for what happened here. The larger you get, the more you approach the size of a small legislature or a large legislature, the more there's diffusion of responsibility where no one person really bears responsibility for what the court does. And that's a bad thing for the kind of legitimacy and responsibility we want for the court. It's true that the court is polarized in the sense that Republicans appoint justices with one set of beliefs or approaches to the bench, and Democrats tend to appoint justices with a different set of beliefs and approaches to the bench. It's polarized because what the Supreme Court does is important. and because people care about how the Supreme Court approaches things, and so they want to see an approach they think is better for the country represented on the court. That's actually what we'd want in a high stakes, high salience decision that actually has impacts on the country. We want to see the government officials who are in charge of it making the best decisions they can with the information they have available to them. And we're not going to get away from polarization as long as the issues that the Supreme Court deals with are very important and affect the things that our politics is divided around. I think everybody regards that as a second best. It would be better if we all agreed on what was good and bad. And so there was no chance for polarization because there was just unanimous agreement on all questions of legal ambiguity and legal approach. But we don't live in that world, and if we did, the Supreme Court wouldn't be very important because there wouldn't be major legal disputes to resolve. But in a world where the Supreme Court is important, I think the polarization is to be expected. Again, this is bracketing the partisan critique. One could say, well, the problem is not polarization, the problem is that too much of the bad guys are there and not enough of the good guys. But that requires us to agree on who are the bad guys and the good guys, and that's the very thing we can't agree on that makes having a Supreme Court and a constitutional system so important. I do think there's an important theme about the court's legitimacy, right? It is a problem that people do not perceive the Supreme Court as more legitimate, and that hurts the Supreme Court's ability to do what we really needed to be able to do, to resolve major legal disputes that threaten to tear the country apart. That said, I don't think you can court reform your way to legitimacy, because I think the marginal changes that would cause people in one camp to think the court is more legitimate will cause people in the other camp to think the court is illegitimate. And this kind of structural reform is largely zero-sum from a legitimacy point of view, right? We could partisan reform or PAC or whatever to put more Democrats on the court, and Democrats might think the court is more legitimate, and Republicans will think the court is less legitimate. So you can sort of move the legitimacy around, but you can't generate legitimacy by changing the composition of the court. One thing that would help generate legitimacy is if the scholars and journalists who write about the court did more to try to encourage people to see the good things that the court does, to see the way in which many of its cases are controlled by legal principle, that even cases that are politically polarized are being decided by justices in good faith, not on the basis of their political priorities, the ways in which justices often go against what you might expect from the politics or policy views we expect them to have. I think a lot of our sort of Supreme Court explaining industry, again in academia and journalism and elsewhere, is often devoted to highlighting things about the court you can get mad at, to showing you what trips the justices have been on, or what they've spent their money on, or what talks they've given in a way that maximizes your ability to see ill in them. And very little of it is spent trying to show you all the things they do that are legitimate and in good faith and ways they work together. And if we spent time doing that, it might help the court's legitimacy a lot. And so in some ways, I think the Supreme Court does have a legitimacy problem, but the problem is not the Supreme Court. The problem is the way a lot of people talk about the Supreme Court, and we could be doing more to honestly help people see what the court is doing that's more legitimate. Last thing I'll say, which does risk being a little bit into the partisan theme, is that I think reforming the Supreme Court is dangerous because, especially in, let's say, today. So Donald Trump will be president for the next 4 years, and he will propose and attempt to do a lot of things that are probably illegal and violate the Constitution. And one thing that might help preserve our constitutional order is if we have some neutral body that's capable of sometimes saying, no, that's unconstitutional and you can't do it. And that somehow will stop or will not provoke J.D. Vance from saying, well, the Supreme Court has said that, but we're going to do it anyway, right? An entity that has legitimacy, but especially legitimacy among the Republican base and the people who will work in the Trump administration, who might be very tempted to ignore what the Supreme Court does. And for that kind of entity, what we most need is a court that has legitimacy among the people it's trying to stop. So this seems like a very bad time. And again, we don't have to think about it in the short term, but it seems like a very bad time to think about trying to make the court less legitimate among the people in power who we might need to stop, even at the marginal gain of its opinion polls, among others. Thanks.
Dan, back to you.
So do I respond?
Why don't you have a conversation, and Deborah and I will butt in.
Okay. So we've talked about some of this stuff before, and I think there's some smaller things to say, bigger things to say. I think some of the things you emphasize seem to be kind of small, right? This idea, that you led with this idea that the justices are going to be auditioning for their next job, and yeah, is that a small thing to be worried about? On the other hand, we're the only country that does it this way, of major countries that has life tenure plus no retirement age. The countries that have a mix of term limits or mandatory retirement age, I don't think this is a huge problem. So, you'd have to just decide how much of a cost you see that as. I guess I do want to clarify something. Maybe we can have this conversation. You said, well, about polarization, right? You said, well, we're always going to see that because there's going to be people saying, I want the good guys and not the bad guys on the court. I think the point is a little different, though. I mean, there's a difference between good guys and bad guys. There's people that we trust more and less, even if we disagree with them, right? There are people that we see as extreme partisans, and there's people that we think they don't share all of our views, but they're going to give us a fair shake, right? I would rather have you be on the Supreme Court and deciding my criminal appeal, if you didn't know who I was, than a Fox News personality, right? And so I think the claim I'm making is that polarization increases the likelihood that you get justices who are more reflexively vote in a way that appears more reflexively partisan.
So because I'm not sure about this. So I think it's true you used to have people in the court like Justice Souter, who was appointed by Republicans and consistently voted with Democrats. So there's a way you could say, well, he was kind of nonpartisan in that he didn't consistently vote with Republicans. He consistently voted with Democrats. Yeah. But he still consistently voted with Democrats. So other than the fact that he was seen by the Bush administration as a failure because they accidentally appointed somebody who was polarized in the wrong direction, I don't know that he did a lot to boost legitimacy of the court. I agree with you that having justices like Neil Gorsuch, who surprises people by voting for the rights of gay employees in Bostock, or Amy Coney Barrett, who regularly breaks with what other conservatives think on sort of a range of issues. I agree with you, that's very good. And you want to see an appointment process that leads you to more justices who are kind of clearly thinking for themselves, taking the cases as they come, and not always part of the team.
So what about Justice Kennedy? I mean, I do think we see a push to have fewer and fewer kind of moderate justices, right? Because even justices like Justices Gorsuch and Barrett, I think there's people in the current administration who sees those justices as failures, right? Mm-hmm. They want people that are even more rock solid, more likely to vote in an ideologically lockstep fashion. Yeah. And I do think someone like, obviously I clerk for Justice Kennedy, I'm very fond of him, but I do think having a justice like him, he was conservative, he voted with liberals in some of the highest profile cases. I do think having justices that vote in that unpredictable way was good for the court's legitimacy. And part of the claim I was making is that we're seeing less and less of that as the sorting at the presidential level becomes more rigidly ideological.
Yeah, and I agree that Justice Kennedy was a great justice, but I'm not sure that there's a structural issue there. So Justice Kennedy is appointed because first, Republicans try to appoint Robert Bork, despite the fact that there's Democratic control of the Senate. And then the Democrats up polarization and sort of have incredibly polarized and politicized confirmation hearings, which they reject Bork, as they're entitled to do. And that led Republicans to first pick Doug Ginsburg, who didn't work out, and then to land on Anthony Kennedy, not because they sort of failed to ideologically sort or didn't know that he was much more moderate than Robert Bork, but because they had to. Now, the last time we had the opportunity for that would have been when Barack Obama was president and Republicans controlled the Senate and the chance to fill Justice Scalia's seat came. And Barack Obama tried to do a version of that, which was to nominate Merrick Garland, who you could see as moderate. But I don't think anybody thinks that a Justice Garland would be as unpredictable or as nonpartisan as Anthony Kennedy was. And even when Republicans said, we're never going to confirm anybody that Barack Obama nominates, I think he could have tried to pick Frank Easterbrook or somebody who would just be sort of unpredictable and potentially gain that kind of legitimacy, and that would have been good. But I'm not sure that's a structural problem, that politicians sometimes shoot the moon and fail.
Yeah, although I was going to go to the Garland example, and I guess my claim would be we've seen so much more divergence in our legal culture that there isn't really a Democratic-appointed judge who could have earned confirmation by the Republican-controlled Senate in a way that might not have been true a generation prior.
Maybe. I mean, again, I do think there's no reason that a Democratic president has to only appoint Democrats. So somebody like Frank Easterbrook, to name him again, is a Republican, but a Republican who believes very strongly in judicial restraint, who has broken with Republican orthodoxy in questions about gun rights and lots of other things. Harvey Wilkinson will be another candidate, right, who's openly sort of disagreed with the direction of things the Supreme Court has gone. I think he's considered a Republican, but he would have been an option. And I think it's a failure of our political imagination, and maybe it's a mistake to try to do structural reform, and what we need to do is just be a little more imaginative.
Okay, I wanted to pick up also, is this working? Is that working?
Yeah.
Yeah, okay. On polarization, because, so you're talking about polarization in the court, but there's clearly polarization in our Congress, and that makes the Congress much less effective as a source of limiting the power of the Supreme Court. And so I worry, you know, we have this system where the Supreme Court has, you know, a lot of power, but it's supposed to be limited in a system of checks and balances. But if the legislative branch is unable to effectively assert its voice because it doesn't anymore have a voice, and we're not seeing people working across the aisle, that gives the court even more power. And then I start worrying, like 5-4, like 5 people are legislating policy because the polarized Congress is unable to. So that feels like something that needs to be fixed, and maybe the fix isn't inside the court, but it makes the court more problematic in its assertion of authority.
Yeah, well, I guess I see that framing, and I do feel like part of that's, I guess, setting the Supreme Court up for a set of unfair expectations. I mean, I think I agree. Polarization has grown, and that's not good. And you know, but that part of what that just means is that we have more polarized legal disputes. We have fewer other institutions that have ways of channeling those and checking them. So we pour more of our expectations into the Supreme Court. It takes on more and more hot button cases, and with more and more of a sense that whatever happens will be treated illegitimate by half the country. And that's not a problem. That's not only not a problem the Supreme Court can solve. That's not a problem that's really fair to ask the Supreme Court to solve. We got to look inside ourselves.
Just to reinforce the polarization point, though, I do think, to go back to the Bork example, it is worth noting, I don't have the numbers at my fingertips, but there were, as I recall, there were Democratic senators who voted to confirm Bork and Republican senators who voted against confirmation. The same is true of the Clarence Thomas confirmation, and we wouldn't see that to the same extent today. There's more lockstep voting on Supreme Court nominations today than there once was.
So I want to stick to polarization for a moment. Granting, you know, when everyone talks about halcyon days, they turn out not to have been quite so wonderful. But it seems to me that there's been a general trend towards Supreme Court justices being confirmed along partisan lines. Is that purely a function of the general polarization we see between the parties in the country, or is there something else going on?
I think it's not just that. I mean, I think there is a cycle to it. I think it's now the salience of Supreme Court nominations in both parties mean that if you're, so Ruth Bader Ginsburg was confirmed virtually unanimously, as was Antonin Scalia, not that many decades ago. And I think part of that's just now you would be politically punished in a primary if you voted to confirm somebody like that on the other side in many, many cases. And that's not just polarization of where people's views are, that's also the way in which national attention has shifted to the Supreme Court, in part producing conversations like this.
Yeah, there are more kind of pressure groups that focus on the judiciary, and I think in ways that didn't exist at all maybe 30 years ago.
So I have a question for both of you. I'm going to begin with Will. Granting that you don't like any reform proposals, what's your least unfavorable?
All right, so two things. So reform proposals that are not about the composition of the court, but are instead about the power of the court, are probably my favorite proposals. So I think if I think of this by analogy to nuclear disarmament, where the Supreme Court is sort of a nuclear weapon, I think fighting for control of the nuclear weapon is very destructive. And figuring out some way to turn down the power and turn off the nuclear weapon would be better. And that might include sort of general limits on the Supreme Court's jurisdiction, its power in particular cases, just diminishing the force and salience of the court in general. For things within the scope of our core question of reforming the membership of the court, I think term limits that operate prospectively, so they don't try to get rid of, John Roberts would be off the court if we had 18-year term limits applied retroactively. He's been on the court for more than 18 years. But term limits that operated only prospectively for new appointments are mostly harmless. I worry that a world of term limits, depending on how long they are, will produce the kind of what's my next job thing, in part because our Supreme Court justices are political celebrities in a way that many others, except in a few exceptions, are not around the globe. But I think probably it would have little effect. I'm also not convinced it would have a lot of positive effect. I'm not convinced it would produce a lot of legitimacy. But that one I think is mostly harmless.
A somewhat technical question, but I think people might be interested. Could one go to term limits with legislation, or would it require a constitutional amendment?
So my view is that there are decent arguments that you could, but the kind of prevailing wisdom is probably not. That it would not be seen as consistent with the requirement that justices get to sit during good behavior. But my view is if the justices retain their title, retain their salaries, I think it is at least consistent with the spirit of those constitutional requirements. But that's not there's support for that view, but it's not the majority view by any means.
Yeah, the standard workaround is that technically the justices would not have 18-year terms. They would have sort of an 18-year period as an active justice where they decided all the Supreme Court cases you've heard of. And then after 18 years, they would still be Supreme Court justices, but they would either not decide cases and do something else, or they would decide a small subset of cases we don't really care about, or be there as stand-ins or something else. And I think those workarounds are probably unconstitutional and wouldn't really work. But.
So my question for Dan, you won't be surprised, is what's your favorite reform?
That's a good question. So actually, I have my own proposals that I put forward some number of years ago. I'm not actually going to defend them. The one that I actually have come around to liking the most is, I like it because it's simple, and it's one that was proposed by Will's former colleague, Daniel Epps, which is, I don't think, and Will, tell me if you disagree, I don't think this one would require any kind of constitutional amendment. Just say there are automatically 2 vacancies for each presidential term. And those justices get to sit for as long as they want. And we're not going to force anyone to retire, but no president, so you don't have the situation where Trump, initially serves for 1 term as president, but gets 3 appointments. Jimmy Carter is president for 1 term, but gets 0. That strikes me as one of the easiest ones to implement, and at least somewhat more defensible than the current state of affairs. What do you think about that one?
So it's interesting. So it's a sort of hybrid between term limits and court packing, in the sense of if the justices all choose to behave like they do now and stay on the court for life, it's court packing. It's just slow court packing by a couple of justices a term. The justices could coalesce around a norm of sitting for only 18-year terms, at which point it would not be court packing. It just sort of would ease into 18-year terms. And so it has the elegance of being somewhere in between the two. So it clearly doesn't require a constitutional amendment because all it's doing is changing when we appoint justices, but it doesn't necessarily result in one side just seizing control of the court because it's a gradual court packing program. I put that also in the category of mostly harmless. I think, to the extent that part of what makes people feel like the court is illegitimate is that Barack Obama did not get twice as many Supreme Court appointments as Donald Trump, and in fact got fewer. To the extent that solves some of the legitimacy problem, that'd be good. It does produce a kind of arms race around how long the justices will serve. If you get 2 justices per term, and then, as long as biology and the justices' proclivities permit, they get to sit. You obviously have incentives to appoint younger and younger and healthier justices to try to maximize, the punch. More so than in the current system, because in the current system, justices can strategically retire, and so you don't have the same sense of like this seat will be an extra vote, no matter what. And that's probably not a good thing, but it's not terrible.
Yeah.
You're also, that seems like it's dependent, first of all, on who wins the presidential election. So it's not a surefire way of depolarizing the court.
I guess the other thing I'd say is it also puts a lot of pressure on the Senate. Yeah. So because then one question becomes, oh wow, if this president gets 2 seats, but we control the Senate, then do you block them? Do you impose maximum demands for concessions, and do we have a sort of Merrick Garland situation forever?
Yeah. I do think it would at least make it less likely that sort of one party can control the court forever by just engaging in a round of strategic retirement. Because if every justice on the court chooses to retire strategically when the party they favor holds the presidency, that party can hold the court forever. Put differently, Democrats are only ever going to have a majority of justices that they've appointed to the court if they get very lucky and someone dies at the right time, which is kind of a grim way to think about it.
I think that's true. Although I think this is one place in which ambition does counteract ambition, is that most Supreme Court justices, even if they have partisan leanings, really like being Supreme Court justices and think they are very good at their jobs. And so it's hard for them to decide to retire when they're still doing the job well. That's how Justice Scalia ended up still on the bench when Barack Obama was president. That's how Ruth Bader Ginsburg ended up still on the bench when Donald Trump was president. Maybe the justices will be more partisan and more self-disciplined in the future, but human nature being what it is, there are probably some lucky breaks coming.
We talked about loss of legitimacy a lot at first. Leaving aside the possibility of ignoring Supreme Court decisions, what are the consequences, do you think, starting with Dan, of continuing loss of legitimacy for the court and its decisions?
So you are suggesting leaving off something that does seem kind of significant, right? There is a non-zero chance we could imagine a world, 5 years, 10 years from now, where the court is seen as so partisan. The court is just seen as the Republican court to a degree that it's not even seen today, where governors in blue states, like my mic, say, we're just going to ignore Supreme Court decisions. We're not there yet. That strikes me as problematic. It would provoke what we call a constitutional crisis of the likes we haven't seen since the 1950s and 1960s when the court was kind of trying to back integration of the public schools in the South. That strikes me as dangerous. I've also made the claim in my academic work that the court has sort of a leading effect in the sense that this is a little bit more speculative, but the claim being that the more people see the Supreme Court as just a partisan institution, that could just bleed into how they feel about law more generally. And that once we just start seeing all of law as a partisan enterprise, a partisan institution, it's just about what team you're on, who wins in the law. That strikes me as very, very dangerous if we care about living in a society that really has, something that we call the rule of law. The rule of law is a phrase, a little bit hard to define, but it's the kind of thing where you kind of know it when you see it, and you know it when it's absent. And my claim that how people think about the court affects how they think about the law more generally is a little bit more speculative, but I think there's reason to worry about that.
Similarly, I think there's a spectrum. There's both directly ignoring Supreme Court decisions, and there's kind of just not taking them in good faith. So the Supreme Court decides 50 cases a year, and the federal courts decide, tens of thousands of cases a year, and most of those will never be reviewed by the Supreme Court, but are in some way governed by the principles the court set forth. And the more there's a sense that the court is illegitimate and the things it says don't really count, even if you don't directly ignore the Supreme Court in a specific case, you just start to see a growing sort of cynicism and destruction of the, any kind of centralized legal principles.
So in terms of, you had mentioned and that the policy you like the best of all the policies you don't like for the court is restricting the scope, cabining what are the prospects for that? Because again, you might worry the court is actually acting like a legislative branch these days, where that's really not what it was supposed to, what it's set up for. It's not what we want the court to do.
I think, the court's original role in the constitutional system was more as a dispute resolution body, not as a sort of oracle of constitutional law or like all policy of the country, but as the place you went when you had a hard dispute about federal law especially, the two parties couldn't disagree, and the Supreme Court would be the arbiter of that specific question. And of course, those could have implications for the whole country. Dred Scott, the New Deal. But there was sort of a sense in which that was the core thing the court was doing, was focusing on the dispute before it. I think the standard political science and historical account is that over the course of the 20th century, politicians in both parties decided they were happier to offload more and more political responsibility to the Supreme Court. That there were hard decisions that they were fighting about, where they might be in a no-win situation with their constituents, and everybody was happy to make everybody else get mad at the Supreme Court. And you see this, in the run-up to Brown and the Civil Rights Movement, is just continuing now. And I think that's probably true now, too, is that there's a real sense in which both parties are happy to have everybody yell at the Supreme Court and offload a little bit of responsibility to them. So in that sense, maybe the prospect of reform is not great, because there's strong incentive among the other institutions to let the court be the lightning rod.
Maybe the 14th Amendment is the source of all the problems.
On the whole, I think it's good.
Before we invite members of the class or auditors to come to the microphones, are there some issues, more or less related to the topic we've been talking about that you'd like to chat about?
One thing that we haven't really talked about at all, but maybe it's just worth keeping in mind, is the question of judicial methodology. And I think maybe that is one way in which we see the kind of ideological sorting of Supreme Court justices, is that there are different schools and approaches in terms of how lawyers and how judges are supposed to interpret the Constitution. And you see conservative judges and justices are likely to identify themselves as originalists. Now, originalists can mean a lot of different things. I understand one of your professors actually invented that phrase. I don't know if I hope that's true. That is a methodology that tends to track more conservative results. Liberal justices tend to follow something that looks more like a kind of evolving approach to the Constitution. Will is a very prominent originalist scholar. He's got his own flavor of originalism. And so I don't have any specific claim about it. I just thought that should be part of the conversation, that's related to what we're talking about.
Well, so here's my favorite Supreme Court reform, is all the Supreme Court justices become originalists. And they all agree that the coin of the realm for constitutional arguments are what were the principles established by the Constitution or its amendments when they were made law. And they understand that there are more, they have conservative and liberal perspectives on that. They might still interpret the Constitution in very different ways. You can read the 14th Amendment in a more radical or less radical way. But if we could get the justices to all coalesce on a common language for legal decision-making, ideally originalism, maybe that would produce more legitimacy. I will note the four most recent appointees to the Supreme Court, Justice Jackson, Justice Barrett, Justice Kavanaugh, Justice Gorsuch, all identified themselves as originalists at their confirmation hearings. So that is how they interpret the Constitution. 7 of the 9 justices have all said they're originalists. I'm not sure they all mean it. But if that's a sort of a potential for reform, that we could at least coalesce on one common project for what the court is doing, maybe that could diminish the polarization Dan's worried about and produce legitimacy.
So we have to take a minute more or two, because I'm not sure everybody knows what it means to be an originalist. So you might explain that. And also, since you have studied this probably the methodology more than anybody else, there are many flavors of originalism. So talk a little bit about that, both of you.
I'm not really an originalist. There are, how many versions of originalism are there? Well,
9.
okay, do you want to give us the core, what are the core axioms of originalism?
The core axiom of originalism is that when the Constitution or a given amendment was enacted, that was the important point at which it kind of made law. And when we're thinking about what the constitutional law is today, we have to go back to that point and sort of understand what it did then, rather than bring in more modern sensibilities or policy preferences about sort of what's happened since then.
And there's different theories in terms of what kinds of evidence you're allowed to look at. And
right. So some people would say original intent. What did the people who enacted this amendment intend to do? What were they trying to do? Other originalists say, no, it's original meaning. It's not what's in the minds of the people who enacted, it's what were the words have meant to a reasonable reader at the time. Other people say, well, you can't just look at the text alone, so you need to use original meaning, but also the original methods of legal interpretations. You read it the way a lawyer would read it at the time. Some originalists say, no, it's really the original law. You want to know sort of the full, as a legal matter, not just the text, but whatever kind of legal rules we had at the time the amendment or the document was enacted, those remain the legal rules until there's been a new amendment, and so on. I don't think the variations are that important. I don't think the justices are engaged in this at that fine-grained of a level. But I think the idea that something important happened at this consensus moment in the past, where somehow, despite polarization, we managed to get 2/3 of each House of Congress and 3/4 of the states to all agree on this legal text, that should be the building block for constitutional law.
And originalists certainly don't all agree on the answer to every legal question, and there's creative originalist arguments for all sorts of really unexpected legal positions. But that said, I'd say on balance, originalist answers are going to tend more towards conservative answers in some disputed legal issues. It is harder. Can you come up with an originalist argument in favor of the abortion right recognized in Roe versus Wade? Yeah, but I would say probably most originalists think that that's not a valid argument.
I agree. This is also something that just shifts over time. So in the 1940s and 50s, the most prominent originalists were liberals who thought the Supreme Court was constricting the powers of Congress and was stopping reform legislation through inventing new doctrines and decisions like Lochner versus New York, and that we need to return to the original meaning of the Constitution to clear the way for reform. Then it became more conservative, so the politics of originalism might change, but on a very slow timeline.
So this has been a great conversation among us. Let's invite people to come. There are 2 microphones, and it's time to expand the questions. While you're lining up, I should just, for the record, I did coin the term in an article that was called The Misconceived Quest for the Original Understanding. You can see how much attention the court has paid to my article over the years. And please, others, don't hesitate to come up.
I have 2 questions. One is for William, and my question to William is, what do you think of, obviously don't want to reform the composition of the court, but what do you think about reforming the way that we appoint justices, like changing that method? And my question for Daniel is, if you're not an originalist, then what are you, and how could there be any alternative to originalism?
All right, I'll answer my question first. So I personally think that abolishing the filibuster for Supreme Court appointments was bad. And it was better when you had to get 60 votes or even 2/3 of the Senate to consent to a Supreme Court appointment, because that meant there was always some cross-partisan, some need to win over some people on their side of the aisle. Maybe not a lot, but something. I think that was good. So personally, I would reinstitute that rule, even through constitutional amendment, if we had to. You know, if we did it, though, I will say the initial going would be rough. Like at first, what would happen is, you know, people would stay partisan and seats would probably be vacant for a little while, and there'd have to be a sort of new round of bargaining over where exactly to end up, but I think that would be better.
Okay, so the question for me, I think, is a fantastic question, and it's a question that liberals have really struggled to answer. There's no shortage of liberal theories of constitutional interpretation that are designed to be kind of alternatives to originalism, but they all suffer from a lot of problems. They've gotten criticized, and I think it is one of the things that I think has been a real failing of some of the, you know, liberal legal culture and liberal justices. So Justices Scalia and Breyer used to do this kind of roadshow where they would go to places like Stanford and have a debate about originalism. And Justice Scalia had a very clear theory, basically, you know, a version of what Will said a second ago. And Justice Breyer would say, oh, you do all this stuff, it's pragmatic, and you look at democracy. And I think it wasn't very persuasive to people. It probably moved people more towards originalism because, you know, whatever liberal justices are doing, it doesn't have a catchy phrase. It's not easy to sell. It's not as easy to market. So I guess in terms of what I am, I would say that I totally think that original understandings are part of the kind of grab bag, the things that go into legal interpretation. I think maybe where I part ways from people like Will is exactly how much primacy I put on that. I think that, you know, we have built up a pretty elaborate set of doctrines in a lot of areas of constitutional law that really has nothing to do with the original understanding. I think people like Will, not all of them, but I think a lot of them are much more interested in kind of clearing the ground and going back to first principles. And I tend to think that precedent should take a much bigger role. There's a little bit more flexibility for judges to engage in kind of common law type reasoning, building on precedent. You know, one of Will's colleagues, David Strauss, has a theory he calls common law constitutional interpretation that I have always thought was a pretty compelling way to understand, at least descriptively, how the court approaches cases. It's not doing originalism. It's kind of just looking at a precedent and saying, okay, where do we want to go with the next case? And I think that's not a terrible way for the court to operate.
So at this road show, one of the jokes Justice Scalia would then always make, or he'd always say, you know, it takes a theory to beat a theory. And he'd tell the story about the, you know, two hunters who are going through the woods and suddenly encounter a grizzly bear, which charges them. And one of the hunters starts running. The other one says, what are you doing? You can't outrun a grizzly bear. And the running hunter with the head start says, I don't have to outrun the grizzly bear, I just have to outrun you, right? And that was his argument, is that originalism was like that. It was not perfect, it was not going to outrun the grizzly bear. But he could make the case it was a lesser evil, a better method than what other people did. And then he would also say, look, if you don't share Justice Scalia or Justice Gorsuch's view of the world, the last thing you should want is for them to be a common law judge making decisions on a kind of normative, pragmatic basis, what they think is reasonable. You should want them to adopt some view of the Constitution that really locks them into something other than their own beliefs, precisely because they might do things in a very different way than you.
And I was just going to say that Will and his frequent co-author, Steve Sachs from Harvard, have been in conversation with Adrian Vermeule, another law professor at Harvard, who is conservative, but offering a very, very different vision of constitutional law and interpretation that is not originalist. It's basically, you know, I think you could describe it as sort of a version of kind of conservative living constitutionalism. And you know, Will wrote a very, very critical book review of Vermeule's book, where he advanced that theory of constitutional interpretation. And I think it's interesting, we're going to start seeing a little bit of divergence on the right, because as we see, you know, conservatives having power on the court, there's already a push to start saying, well, maybe we shouldn't be quite as restrained by this originalism stuff. Maybe we should just kind of be willing to kind of rewrite some of these doctrines in ways that lead to results that we like.
Yeah, no, I think now originalists are going to be attacked on the right for being wimps. They're going to say, look, we finally got the court. Now it's time to tear off the mask of originalism and be the true, you know, conservative, right-wing partisans that we always wanted to be. And I think you're going to see some people say, no. It's not time to do that. We need to stick to principle.
It's interesting to think of originalists as a moderating force, but that's that's an interesting role. When you were asked the question about appointments to the court, I thought you might go in a different direction. And so for somebody who's watched the process, it sometimes feels like you can't have had any view on anything consequential, or at least you have to say you don't have a view on anything consequential, because having a view will get you disqualified by one side or the other. That was a problem of the maybe older system. And I wonder what you think about that, because there are if you think back to the kind of appointments that were made, a generation ago, and I'm probably idealizing the past, but it felt like there was more, like you could be a political leader and get appointed to the court. It was less risk averse or less, you didn't have to find somebody who'd never done anything, but it feels like sometimes you have to find somebody who's never ruled on anything and never taken a controversial position, even though they have those positions and everybody knows they do.
So one thing that's just generally changed is I think the expectation on both sides has been that a Supreme Court nominee should be somebody who has experience, probably as an appellate judge, at doing technical law. And it's not particularly good and probably bad to have experience doing non-technical law stuff, like being a senator or a governor or anything like that. I don't think that's all bad. I think that partly reflects more of a sense that the Supreme Court has just gotten more legalized and technical and is approaching its cases in a more technical way, which I think is actually good for the rule of law. That piece of it, I think, is good. I do think that, though, you're right about this kind of the idea that you have to pretend you don't have any legal views. I think there was a specific aspect of kind of performative ignorance around abortion and Roe versus Wade, where especially if you were a Republican nominee, you had to pretend that you didn't know whether you thought Roe versus Wade was right or wrong, and it was kind of an interesting open question what you might do if you were one day asked to reconsider it. I don't think anybody really believed this, and I think sometimes the questions would be carefully worded, like they sort of worked out a script. So the nominee would say, "Oh, Roe is a settled precedent," which is descriptively true. It is a precedent and is currently settled. That doesn't tell you whether it will be unsettled in the future. And everybody kind of knew that those magic words would both be reassuring but not really do anything. And I think that was not a good feature of our politics. It'll be interesting to see if Dobbs and the fact that Roe is not settled precedent anymore changes that in a good way or just in a worse way.
I do wonder whether things might be swinging back in the other direction, though, that this culture of picking these very, very safe nominees was a function of the Senate filibuster. And I think, to the kind of height of that, the last era, justices on both sides, people like Chief Justice Roberts and Justice Kagan, who were both incredibly brilliant, talented lawyers, but who I think had been very, very careful their entire careers to avoid saying things that they could really be pinned down on some of the most contentious legal issues. And I think those are two of our most impressive justices on the court. I don't love a system that incentivizes people that way, because I respect people who are willing to say what they think, and I don't think people should have to spend their whole careers kind of being really cautious and not saying anything controversial. I think that we should not encourage that.
So before we wrap up and bring it back to the poll question, since I have two people who are very thoughtful about originalism here, let me pose this initially to Will. You can think of originalism as a spectrum, and partly I'd like to know where you are. And I'm not sure that that you'll agree with this continuum, but here's one end is you always have to read any text in the light of the general purposes that whoever wrote the text had. You can't read the text outside of some social context. So, the president, the Constitution requires the president be a natural-born citizen. Anybody who said that means that somebody born out of a cesarean section couldn't be president, although it fits the text, would simply be misreading the way any of us read. That's one extreme, where you read the text in the light of its general purpose. But, and for some of the more open-ended constitutional provisions, there are lots of possible readings. The other end are the Supreme Court's gun control decisions, where, leaving aside the preamble, whatever the preamble means, you know, the question that originalists were asking was this particular gun control regulation or something very closely analogous to it, was that permitted in 1787 or 1791? I'm not sure that's the best way of describing the continuum, but whatever it is, where do you sit and what's Dan's view?
So I'm much closer to the Supreme Court's gun control decisions. Or I mean, in fact, I do think they are model decisions for how to interpret and apply the Constitution. I think they do allow a little more flexibility than the version you described, so that's what I'd say. But I think they are trying to say, you know, what are the fundamental principles that this constitutional amendment set up at the time, and even if those set up a balance that we now think is quite bad, even if we now think, as I do, that, you know, handguns probably cause a lot of mischief, and it would be good if there was some way to have a lot fewer of them. If the Constitution has set a different balance, then our job is to kind of be faithful to its balance until we can get enough of a consensus to amend the Constitution and do something else. And I do think that requires often a kind of a thick investigation of what kinds of purposes could you have a gun control regime for, what kinds of restrictions are reasonable, and so on.
The gun control cases present a great example for, you know, my skepticism of the hardcore version of originalism, because I see those as cases where a lot of other factors cut in the other direction, right? We have, you know, we went a couple hundred years before the court had to step in and start saying there's an individual right here. They involve the court second-guessing the results of the democratic process pretty aggressively, upending compromises that legislatures have made pretty aggressively, and potentially producing results in the country that are very bad. And so for me, you know, however much weight, whatever you believe the original understanding might say, I would prefer that judges put a little bit less weight on that when all the other considerations tip, in my view, in a different direction.
One more question, that's great.
Oh, yes. I have a question for each of you. For William, you said earlier that you were concerned that removing lifetime appointments for justices would cause them to start considering their future jobs while they were on the bench. I was just wondering if the reporting of justices having close relationships with wealthy individuals and going on vacations with them also concerns you, in the sense that justices may be taking into account personal considerations while making decisions on the court. And for Daniel, I was wondering if we tried to reform the Supreme Court legislatively, is it possible that a Supreme Court hostile to reform would just overrule any of those reforms as unconstitutional?
Okay. No, it doesn't worry me at all that the Supreme Court justices like to hang out with and have favors lavished upon them by random billionaires that nobody heard of until ProPublica started investigating this. I think there's a way in which this phenomenon is not new. Again, for justices who are more on the left side of the spectrum, this goes on they go to expensive retreats and lectures and seminars hosted by NYU at their Scotland campus, or they get awarded a Medal of Freedom from various nonprofits. And they, groups that like what the justices do spend a lot of time trying to celebrate them and trying to spend time on them. As I think the conservative kind of elite ecosystem developed its own kind of parallel ecosystem where they go to different galas and eat different rubber chickens and hang out at different resorts. And I think it's not surprising that that's happened. I guess I do think it's not a great look, right? I think it does cause people to suspect that the Supreme Court justices are corrupt or doing things because they want to stay friends with this billionaire who will let them go on their yacht or get to go hang out at the Bohemian Grove, which frankly I don't think is true. I think the justices are far more committed to their interpretive theories and their ideologies than they are to any of these kind of perks. So I don't think that Justice Thomas is secretly an abortion rights supporter who kind of joined Dobbs just because he wanted to make sure that he still got to hang out with rich people. I think it's entirely the other way around. But it, in some sense, needlessly puts the Supreme Court in a light where people can worry about it. So I'd rather the justices behaved as if they're above suspicion, but it doesn't bother me.
So I'll just say at the outset, I promise that question was not a plant. On our podcast, Will and I have debated the Supreme Court ethics questions a couple dozen times, and he really hates these discussions, and he never wants to admit that the justices are doing anything remotely improper. So
They're not.
I'm glad that he got put on the spot again. But the question for me, is there a chance the justices themselves might strike down a reform? Absolutely. And I do think that's one of the many factors that makes reform very, very hard to accomplish. The thing that is maybe troubling is that some of the reforms, the easier the reform is to do, the kind of maybe worse the reform is for everybody, in the sense that there is, most consensus that Congress has the power to just expand the size of the court, to engage in, permit the president to pack the court. Now, there are arguments that maybe that can't be used in certain ways. Maybe it can't be used for partisan reasons. And that issue came up during the famous court packing crisis during the Franklin Delano Roosevelt presidency. But I'd say, more people think that it would be constitutional just to add 5 justices to the court tomorrow than think it would be constitutional to, by statute, impose term limits or do a number of other reforms. And if that happens and the court says, no, we just won't go along with this, you do have, again, what we call a constitutional crisis. And it's very dangerous territory for everybody.
So before we thank our speakers, could we put up the poll again and see what you think? I think people have had a chance to register their views. Let's see how it comes out. So, what was it before?
It was 70-30. Now it's 80-20.
So I guess we need to reform the court.
It's resolved.
Careful what you wish for.
So
I'm very grateful to everyone in this room. I'm gonna be teasing him about this for the rest of our professional lives. Yeah.
So I should just note that for those of you enrolled in the course, next week is another constitutional law week, and then you get a certificate. You can, if you go to law school, you can skip con law after these 2 classes. But for now, let me just thank both of our speakers who just modeled the kind of discourse we would like to have.